Welcome to Middle Class Matters, Business News in English from Dr. CMA Allegation. Securities Exchange Board of India, SEBI, issues an order, confirmatory order, in debarring Mr. Subash Chandra and Punit Goenka, the Chairman MD of ZEE Limited, from holding directorship or key managerial personnel in any of the companies, including merged and demerged entities. Merger has taken place, ZEE and Sony. In Sony also they cannot hold any directorship. Continued. Next portion. 26.4. Entity number 1 has not submitted any documentary evidence including bank statements to evidence that he had the ability to ensure that a fixed deposit of INR 200 crore can be made by him in his personal capacity, nor is his case that he made such a fixed deposit. Thus, in a way, creation of the fixed deposit by ZEE Limited was seemingly effective discharge of entity number 1's obligation to ensure that a fixed deposit of INR 200 crore would be placed by SL Group with Yes Bank Limited. 26.5. Even a bare reading of the LOC also leads to an inference that entity number 1 had not returned the LOC in his personal capacity, as though the LOC he is conveying to Yes Bank Limited that companies belonging to SL Group, including ZEE Limited, would ensure that a fixed deposit of at least INR 200 crore would be available with Yes Bank Limited. If he was writing in his personal capacity, then he should have no reason to refer to companies belonging to SL Group. 26.6. Yes Bank Limited, while its letter dated October 11, 2019, had in its communication with ZEE Limited regarding the appropriation of the fixed deposit, had referred to the LOC issued by entity number 1 in favor of the bank for the financial assistance given by Yes Bank Limited to various companies of SL Group. It had also further stated that various possibilities including appropriation of fixed deposit by Yes Bank Limited was discussed with the leadership team of SL Group companies. There is no material available on record or has been submitted by the entities to show that they had raised any objection with Yes Bank Limited regarding the LOC being issued by entity number 1 in his official capacity or personal capacity. 27. Entity number 1 had placed reliance on the order of Honorable Bombay High Court in the matter of Yes Bank Limited was a ZEE Entertainment Enterprises Limited and others orders decided on August 19, 2020, wherein it was held that LOC was not in the nature of a guarantee and therefore could not have been interpreted in that way. 28. On the aspect of whether or not LOC is in the nature of guarantee, I have read the order of Honorable High Court in the matter of Yes Bank Limited relied upon by entity number 1. The LOC which was in question in the said order was the LOC dated May 31st, 2016 given by entity number 2 to Yes Bank Limited to facilitate the borrowing by Living Entertainment Limited, Mauritius. The Honorable High Court, after examining the contents of the said LOC and conduct of the parties, found that LOC dated 31st March 2016 given by entity number 2 to Yes Bank Limited was not a guarantee and inter alia held as follows. In a given case, a letter of comfort may indeed amount to a guarantee. Not every letter of comfort is ipso facto a guarantee. The nomenclature is unimportant, as is the absence of the word guarantee. The document is to be construed as a whole, read in a reasonable commercial sense and in the context of events and associated documents. Whether the document in question is a guarantee or not depends upon the exact terms to which the guarantor binds himself. In law, no guarantor is liable for more than what the guarantor has undertaken. The contact of the parties is a relevant factor in assessing the construction of any contract. 29.1. 29. I note that aforesaid order of the Honorable Bombay High Court was limited to the LOC dated 31st May 2016. It has been held by the Honorable High Court that there can be situations where a LOC can be treated as a guarantee. Therefore, to submit that the instant LOC dated 4th September 2018 was not a guarantee, as the Honorable High Court has held that LOC dated May 31st 2016 was not a guarantee, is an incorrect understanding of the said order. I have gone through the contents of both the LOCs. The content of both the LOCs are different. Wise. In the LOC dated September 4th 2018, the writer commits to ensure that a fixed deposit of at least INR 200 crore would be available with Yes Bank Limited, whereas LOC dated May 31st 2016 states that it would support ATL Media Limited, subsidiary of ZEE Limited, which had put option agreement in place with the borrower by infusing equity or debt for meeting all its working capital requirements, etc. Unlike in the case of LOC dated May 31st 2016, where there was legal dispute between ZEE Limited and Yes Bank Limited regarding the LOC dated 31st May 2016. In the instant case, both ZEE Limited and Yes Bank Limited had resolved the matter on July 22, 2020 pertaining to the fixed deposit, which was liquidated on the strength of the LOC dated September 4th 2018 by way of Yes Bank Limited adjusting the fixed deposit towards the dues of the borrowers and ZEE Limited by seemingly recovering the amount from the borrowers. Thus, in effect, as far as the Yes Bank Limited was concerned, the LOC acted as a guarantee. I note that under the terms of the settlement, Yes Bank Limited had kept the proceeds of the fixed deposits of INR 200 crore. Therefore, it can be seen from the above that the facts and circumstances of the two matters are different. Hence, I am of the view that the reliance placed by the entity number 1 on the order of the Honorable Bombay High Court is misplaced. 30. Without prejudice to the above contentions, entity number 1 has submitted that a bare perusal of the contents of the LOC would show that the LOC was issued for the loans outstanding, specifically in SL Green Mobility Limited, and not for the outstanding loans of other borrower entities. Therefore, the appropriation by Yes Bank Limited of ZEE Limited's fixed deposit for borrowing entities was without any authorization. 31. In this regard, I would note that there are more facts involved in the appropriation of fixed deposit of INR 200 crore by Yes Bank Limited. To the extent that the LOC was for the outstanding loan of SL Green Mobility Limited, entity number 1 is correct. But what the entity number 1 is not presenting is the fact that as on July 24, 2019, when Yes Bank Limited liquidated the fixed deposit, the total outstanding amount of companies belonging to SL Group, including SL Green Mobility Limited, which had INR 200 crore outstanding, was INR 8,470 crore. Yes Bank Limited, after having discussed with the leadership team of SL Group of companies, as claimed by Yes Bank Limited in its letter dated 11th October 2019, decided to adjust the fixed deposit towards dues of the 7 associate entities rather than that of SL Green Mobility Limited. Whether Yes Bank Limited could have appropriated the fixed deposit in the first place is a matter of dispute between Yes Bank Limited and ZEE Limited, which they have settled as on date, as discussed earlier, in a manner that lends credence to the assurance given by entity number 1 to Yes Bank Limited in the LOC. However, for the purpose of the instance matter, the fact remains that the LOC was issued by the entity number 1, and on the strength of the same, as expressly communicated by Yes Bank Limited to ZEE Limited, the fixed deposit of INR 200 crore was liquidated by Yes Bank Limited as noted in the preceding paragraphs based on the available materials entity number 1 has not been able to substantiate that LOC was issued in his personal capacity. To put it differently, whether the appropriation by Yes Bank Limited of ZEE Limited's fixed deposit for borrowing entities was without authorization, although settled by ZEE Limited, is not germane in the instant matter, which deals with the issuance of LOC and circular non-genuine transactions. Fund transfers. 32. The next issue that arises for consideration is whether the entities have been able to demonstrate that the 6 associate entities have genuinely transferred funds to ZEE Limited equivalent to the fixed deposit that was liquidated by Yes Bank Limited for the dues of the 6 associate entities. 33. The aforesaid issue has to be answered on the following parameters. 33.1. Whether the entities have been able to refute the prima facie finding of the interim order that the fund transaction between various companies and or body corporates which are part of the prima facie scheme are non-genuine transactions. 33.2. Whether on a preponderance of probability basis the entities have been able to refute the prima facie findings of the interim order that the circular movement of funds was by design and not coincidence. Please like the video, subscribe to the channel, share this video as an information to your friends on the various happenings in the corporate companies of how they are managing the funds as an educational video. Please forward it to your friends. Thanks for watching.